Now, let me begin with our discussing the first panel, which will be on the drug guidelines. Last year, the Commission took a major step to advance our statutorily mandated purpose of responding to growing prison populations and costs by reducing guideline levels for most drug trafficking offenses. This year, we are examining the narrower and more targeted issue of the appropriate guideline level for hydrocodone, which was recently rescheduled by the Drug Enforcement Administration. We will hear from experts from the Drug Enforcement Administration and the Food and Drug Administration, and from an assistant federal public defender, as well as pharmaceutical experts. The following two panels on, after the two panels on drug issues, will turn to economic crime, which has been a major focus for the Commission for the last few years. In fact, it started almost as I became chair. We've conducted exhaustive outreach, consulted with experts, and performed comprehensive data analysis. In September 2013, we held a symposium in New York at the John Jay College of Criminal Justice. Participants included stakeholders, prosecutors, defenders, probation officers from all over the country, and we discussed the fraud guidelines. Among other things, we heard stakeholders express concerns about the impact of the loss and victim tables. Beginning in 2012, the Department of Justice acknowledged that the cumulative impact of the two can sometimes be disproportionate in fraud in the market cases. As I explained in more detail at our public meeting in January, this extensive process, a multi-year process, has led us to believe that the fraud guidelines may not be fundamentally broken for most forms of fraud, but we have identified some problem areas where changes may be necessary. So we look forward to hearing from experts today about whether our proposed amendments would be helpful in addressing problems with the guidelines governing economic crime. We will hear on that issue from expert practitioners, including a United States attorney and a federal public defender, and a panel of representatives from the Commission's excellent advisory groups and from important advocates on white-collar sentencing issues. We are also considering other kinds of important amendments today. We will hear from a panel of experts to help us resolve a circuit conflict about the so-called single sentence rule, to examine whether changes are necessary, to the mitigating role adjustment, and to the guideline governing jointly undertaken criminal activity, as well as considering whether and how we should adjust the monetary tables in the sentencing guidelines for inflation. Now, although we are holding the hearing today, our comment period is actually open through March 18th. So for anyone who has not submitted comments or want to submit more, we are here. We are open to hear from you in addition to the witnesses on the amendments today. So welcome to everyone. There are a few things I'd like to say. Please don't read your statement. I know you've all been warned about don't read your statement. But as a practical matter, we've read your statements. We get them on email. We get them in hard print. We've read your statements. Just give us a synopsis of what you have to say. We're sometimes alive. We'll have questions for you afterwards. The way it works is you'll each make your statements, and then we'll ask questions. It's like we have this little light system that goes off, and basically, I give you the hook at some point. So I'm warning that in advance so I don't seem rude if I do that. Now, I'd like to introduce the other members of the commission. To my immediate right is Judge Charles Breyer. He is a senior district judge for the Northern District of California. Judge Breyer has served as a United States District Court judge since 1998. He joined the commission 2 years ago and is now a vice chair. Now, Judge William Pryor also joined the commission 2 years ago. You don't see him right now because he's in an airplane. He comes in from Alabama, and his plane was canceled, but he will be here later this morning. He is a United States Circuit Court judge for the 11th Circuit Court of Appeals, appointed in 2004. Before his appointment to the federal bench, Judge Pryor served as Attorney General for the state of Alabama. Next is Rachel Barco, who also joined 2 years ago. Commissioner Barco is a Siegel Family Professor of Regulatory Law and Policy at the New York University School of Law, where she focuses her teaching and research on criminal and administrative law. She also serves as the faculty director of the Center on the Administration of Criminal Law at the law school. To my immediate left is Dabney Friedrich, who has served on the commission since 2006. Immediately prior to her appointment to the commission, Commissioner Friedrich served as associate counsel at the White House. She previously served as counsel to Chairman Orrin Hatch of the United States Senate Judiciary Committee and as an assistant U.S. attorney, first for the Southern District of California and then for the Eastern District of Virginia. And finally, far over to my right is Commissioner Jonathan Wroblewski. Commissioner Wroblewski is the designated ex-officio member of the United States Sentencing Commission, representing the Department of Justice. Mr. Wroblewski serves as Director of the Office of Policy and Legislation in the Department's Criminal Division. And so, welcome to everybody again. We're going to get going on our first panel. And I want to introduce you all, and thank you for coming. Joseph T. Rannazzisi, did I say that correctly?
Perfect.
Is the Deputy Assistant Administrator for the Office of Diversion at the United States Drug Enforcement Agency. He has served in his current position since 2006 and has been employed at the at the DEA since 1986. And next to him is Lex A. Coleman, an Assistant Federal Public Defender in the Office of the Federal Public Defender in the Southern District of West Virginia. He joined the office in 2006 after working in private practice for 14 years. We welcome you, and we'll start with you, Mr. Rannazzisi.
Thank you, Judge Saris. Chief Judge Saris, Vice Chair Breyer, and distinguished members of the United States Sentencing Commission, good morning. Thank you for the opportunity to represent the Department of Justice today to discuss the Commission's proposed amendment for a single marijuana equivalency for all hydrocodone offenses based on the actual weight of the hydrocodone tablet. In my limited time frame this morning, I'd like to highlight some of the important points outlined in the Department's position paper provided to the Commission. As you know, almost 15 years ago, for almost 15 years, and after 15 years of looking at the drug, we finally upscheduled hydrocodone products from Schedule 3 to Schedule 2, and that occurred in 2014. My office, the Drug Enforcement Administration, the Office of Diversion Control, was responsible for promulgating that change, and I can tell you unequivocally that the change was supported by overwhelming critical scientific and statistical information. That change righted a legal fiction. When the Controlled Substances Act was enacted, Congress placed single-entity hydrocodone products, such as today's Hydro or the Hysingla ER product, in Schedule 2. But they placed all other hydrocodone combination products in Schedule 3. There's a fiction to place those combination products in Schedule 3 rather than Schedule 2 because they both present comparable abuse liabilities. Not only am I a sworn police officer, but I'm also a licensed pharmacist. I studied all the materials in support of upscheduling, and I testified before the FDA public meeting on the issue. When the DEA upscheduled hydrocodone combination products, we looked very closely at its abuse liability and compared it to oxycodone. And I can tell you that the scientific data, law enforcement data, and other evidence established that hydrocodone and oxycodone have substantially similar potencies, abuse potential, and adverse health consequences and public health effects. They are also similar in the chemical structures, meaning in their mechanism of pharmacologic action. The Commission proposed amending the sentencing guidelines to conform to scheduling parity. The Department supports the changes and specifically recommends that the Commission adopt an actual weight of hydrocodone measured at marijuana equivalency of 1 gram of hydrocodone to 6,700 grams of marijuana. This is purposefully and appropriately the same equivalency of oxycodone. The proposed amendment also provides a single marijuana equivalency for all hydrocodone offenses based on the actual weight of hydrocodone involved and opposed to the number of pills involved, the weight of the pills. The Department believes that using the actual amount of hydrocodone to set offense levels best achieves the goal of proportionality. Hydrocodone is available in varying degrees and dosage strengths in varying combinations. If the number of pills or weight of an entire pill is used to set the offense levels, an offense involving a smaller actual amount of hydrocodone can be greater than the amount of the total pill. Using the actual amount of hydrocodone will better reflect the defendant's culpability. The Commission has adopted this approach for offenses involving oxycodone, which is also available in varying dosage units and combinations. The Department does not see any justification to treat hydrocodone differently than oxycodone. The Commission proposes a marijuana equivalency under which 1 gram of hydrocodone actual equates to either 4,467 or 6,700 grams of marijuana. The Department recommends the Commission adopt a drug equivalency of 6,700 grams. Of the two options, an equivalency of 6,700 grams mirrors oxycodone and reflects the close relationship between hydrocodone and oxycodone. Both drugs have caused similarly significant harm to the public health. Usage data suggests that hydrocodone abusers freely substitute hydrocodone with oxycodone and heroin with the ebb and flow in availability and price. Abusers take hydrocodone and oxycodone interchangeably to achieve the same high. Since 2004, both drugs have been responsible for tens of thousands of emergency room visits. On a per kilo basis, the potential of hydrocodone products associated with death is similar to that of oxycodone. Law enforcement investigations show that the rates of diversion per kilo of hydrocodone products distributed have been largely similar to those of oxycodone products. And in fact, the rogue pain clinics, hydrocodone and oxycodone are the primarily drugs distributed out of those clinics, and the only explanation appears to be geography. I hope this brief summary has been helpful. I'm happy to answer any questions you may have to help the Commission develop an appropriate sentencing scheme for hydrocodone. And I appreciate the invitation to testify before you today. Thank you.
Thank you, Mr. Rannazzisi. Mr. Coleman?
Your Honor, Commissioners, the panel, thank you for having me. This is my first time to the rodeo, and I appreciate the interest and invitation. The government's written testimony, and now what I've heard from my co-panelist is I'm hearing a lot of numbers and data. I'm here as a line defender. I'm here as someone dealing with this daily and representing not just the defender organization, but I believe the citizens I defend on a daily basis. I heard rogue clinics. I hear all these big numbers suggesting that there's this huge public health impact and that geography is the only thing that distinguishes a drug involved. I'm here in part because my district was apparently, according to 2 editions of Quick Facts, the 5th highest oxycodone district for fiscal year 2012 and then 2013. Our judges read that before we were aware of it. They brought that up in some sentencings, and I only looked at the raw numbers and saw 55 for fiscal year 2012 and 57 for fiscal year 2013. These were defendants. For fiscal year 2012, that was only 31 cases. One of those cases was a Rule 20 transferee from Virginia who had some type of opiate conviction in that district and was going to serve her probation in West Virginia. The people who are going to be most heavily impacted by this amendment are not going to be the big pill mills and the doctors. The ones who are going crazy with high volumes of opiates that are being illicitly distributed will be readily captured by a unit basis or even the 500 multiplier that exists in the drug equivalency table. My clients have been, for example, a gentleman named Jermaine Holland. These are all from fiscal year 2013 and 2014. He was a 31-year-old African-American male. He was rehabbing houses in Bluefield, West Virginia. His attributable drug quantity in the case was 8 hydromorphone 4-milligram pills. This was done through 2 controlled buys of someone coming up to the house. He ended up with a base offense level or marijuana equivalency that actually would have been under the asterisk 12 that's in the drug equivalency table. Kayla Lindsay was a 20-year-old pregnant Caucasian female. She was arrested on 3 controlled buys with a total drug quantity involved of 3.5 oxycodone 30-milligram tablets and 5 oxycodone 15s. She again came up with a base offense level through the marijuana equivalency of under 12 and had to come up. Robert Black was a 49-year-old divorced Caucasian male in Huntington who did have a record, but then was arrested and prosecuted for 10 30-milligram oxycodone tablets. David Embry was a 42-year-old Caucasian male visiting Raleigh County from Maryland, coming to see his grandchild his son had had. They found 7.5 morphine sulfate 30-milligram tablets in his car, and he was indicted for that in federal court. Without the asterisks on the drug equivalency node, all of these people would have had under base offense level 12 guideline ranges in terms of seriousness. Had all these tablets been HCPs or hydrocodone, we would have been down toward a base offense level of 6. With the shift to Schedule 2 now, they would have been immediately subjected to 12. They were anyway because of the drugs involved, but had it been hydrocodone, they would have been subjected to the worst punishment. And if we go to a multiplier of 6,700, even at active ingredient weight, we're looking at substantially higher sentences for them. It's been frustrating enough as a line defender when I have so many of these types cases, and we have some of the big ones too, but these by far are a higher proportion in my district, that I'm going to them and explaining how you can't have the benefit of the drugs -2. You've got a base 12 stuck in your drug equivalency table. They see that all their buddies who were doing heroin at 5 grams or more, or even but lower levels pre-guidelines, getting this 2-level break and writing in and getting the motions, and we get countless letters from other clients going, why does that affect me? And I have to send them a copy again of the drug equivalency table with that. It's like, yeah, that's why you still have to do your year and a day. So this change, while I read the government's testimony, and there's certainly statistics out there, if you look at the top 5 pill districts that have been identified in the country, 3 of them for fiscal 2013 involve Appalachia. They involve Eastern Kentucky, Eastern Tennessee, and the Southern District of West Virginia. And you need to understand the demographic of who's there. These are not big-time drug traffickers. These are people who have not had adequate education, who have always had some economic struggle from them because of the dynamics of West Virginia's economy. The large majority of them are honest people who work very, very hard, and they ruin their knees, their shoulders, their backs in the mines. They're put on pain medication when they're chronically disabled and they have chronic pain issues. And in these poor communities, oh gosh, I got a red light, I'm sorry. I'll quickly wrap up.
Get a little of his time, he didn't quite.
Okay, thank you. But in these communities, you already have a type of barter system. You know, my doctor was gone, my car was broken down. I couldn't get into Beckley to get my prescription refilled. And they share. And then later they sell because they need some gas money or they want to buy something to eat. And there are plenty of cases where that expands, but when you see 2, 3, 4-pill transactions, these are the ones who are going to be swept up if you leave the HCPs in the drug quantity table. And our position, to sum that up quickly, is put the Schedule 2 HCPs back out as a separate part of that advisory note. Change the Schedule 2 to Schedule 3, but put HCP. For the actual single entity, while the Defender organization believes we need to restructure this whole thing for reasons that are set forth in our written testimony, certainly in the interim, this year is a stopgap. It is beyond me how justice has gotten from 1675 in 2009 to now a full-blown 6,700 because we're just like oxycodone. We've cited studies, 9 different studies in our written testimony that show the abuse liability is not the same. The market structure is not the same. You do not see, my question, I guess, from the federal perspective is, if hydrocodone is par for par with oxycodone, where are the cases? My last hydrocodone case was the first year I got with the Public Defender Office here in 2006. It was a pharmacist. She was in a 6x8 area working and self-medicated. So she didn't distribute. So thank you for your time.
Well, thank you. Questions?
Mr. Rannazzisi, my question, we had comments, you might not have seen them because it's for another panel actually, but our probation officers advisory group had told us that it was their experience in the field and with their contract treatment providers that it turns out hydrocodone really isn't the drug of choice. That, you know, just in terms of actual usage and practice, they called it a maintenance opiate and an introductory one, but it's not. You know, they suggested that if we were to actually look at real-world market dynamics, that they're not equivalent. And so the probation officers had supported the other ratio. Not the 6,700, but the 4467. And I'm just wondering if you could comment on why their experience might be different from some of the things that you had cited.
Oh, absolutely. Thank you. I deal in real-world market values, too. To say that there are different marketplaces for these drugs is not actually accurate. There are different geographic locations where these drugs are dispensed. But if you look back to the early 2000s, the number one drug of abuse, the number one in the pharmaceutical realm, the number one drug that was being diverted was hydrocodone. How was it being diverted? It was being diverted over the internet. And just in one case, we had 34 internet facilitation sites. Now the average, and each internet facilitation site was a brick and mortar pharmacy. Now the average pharmacy in that time period, in 2006, dispensed about 70,000 hydrocodone tablets. Those 34 pharmacies dispensed over 98 million tablets in total. Now, where were they going? They were going to places like Kentucky and Tennessee. In Kentucky, it got so bad that they were following the common carrier trucks to see if they could get their packages off the truck before they're delivered to the locations they were supposed to go to. Now, that all changed after Ryan Haight came into effect. The Ryan Haight Act basically shut down the internet. So what did we see? We saw a total shift in what was being dispensed. We saw a total shift. Internet went away, and we started seeing pain clinics. Now, what's interesting to note is if you were in Texas, your pain clinics were doing hydrocodone. But if you were in Florida, which was where all the internet pharmacies were, they moved to oxycodone. So you had the Texas people at hydrocodone and the Florida people at oxycodone, dispensing in huge quantities. Now, they always say, well, why is it that somebody would go from hydrocodone to oxycodone? Well, it's because you build a tolerance to the drug. Eventually, you're going to need more drug. Now, the problem is, up until this year, last year, there was no single entity hydrocodone high potency tablet. The highest tablet you could get was a 10 milligram hydrocodone tablet. That was it. But what we saw was 15 and 30 milligram oxycodone immediate release tablets. And everybody who couldn't go to those hydrocodone anymore because they needed 10, 12, 14, 20 tablets to get that same effect, they started moving to the oxycodone. But it's not because the oxycodone was any more potent. It was because there was more drug, active ingredient, in the dosage forms. Now, I would like to see what would have happened if there was a single entity product on the marketplace when all this was occurring, but there wasn't. And we don't know exactly what's going to happen with those single entity products now that hydrocodone is in Schedule 2. But I could tell you that if you're in different places of the country, like I understand that in West Virginia, oxycodone is king. Of course it is. I've been to West Virginia. Actually, I went up to Oceana, which is near Beckley, and I talked to community groups up there a couple of years ago, and they were saying oxycodone is just ravaging their community. But I could go to several communities in Appalachia, Texas, and hydrocodone is the king still. And it'll always be the king because now they have the single entity high potency hydrocodone tablets, and once they're made available, once they're out in the open marketplace, that's what they're going to. It's not a marketplace issue. They're both coming out of rogue pain clinics. They're both coming out of dealers. There are dealers who are dealing both drugs.
How many prosecutions have you had for hydrocodone? What's the comparison between that and the oxy?
I can't tell you prosecutions. I could tell you cases.
You mean open investigations?
Yeah, investigations. Our NIFLA stat, our National Forensic Lab Information System, when we talk about National Forensic Lab Information System, these are samples of drugs going in that are related to a case. Hydrocodone cases far exceeded oxycodone cases in 2000 to 2008. But there was a substantial shift in 2009. Oxycodone started to be king, and the hydrocodone cases started to go away because there was a shift in Florida.
So the last few years, what would you say the differences between?
Oxycodone definitely was more than hydrocodone.
Do you have a ballpark number for the two?
I could give you the NIFLS, the number of NIFLS cases. In 2000,
Say 12 or 13 or something, 14?
in 2012, we had 34,832 case samples
For,
for hydrocodones, the hydrocodone products. That was pre-single entity high potency products. These are just the combination, the 5, 7.5, and 10 milligrams, as compared to 41,915 for the oxycodone products. That includes the high-dose oxycodone, the OxyContin 60s and 80s. It includes Percocet, Percodan, which is a 5, 7.5, and 10 milligram tablet. That includes
When you say cases, what do you mean?
when a law enforcement agency does an arrest or search warrant or an undercover purchase, they take the drugs and they send it into state, local, and federal labs for analysis. Each one of those drug samples opens a case. They have to have a case number to open it. So that would be the cases. So that samples, now there could be several samples under that case number, but that's the number of case numbers that were opened.
Judge Friedrich, Commissioner Friedrich and Judge Breyer.
Mr. Rannazzisi,
Yes.
Mr. Coleman makes a compelling point in his written testimony that the commission may have strayed off course in 2003 when we changed the marijuana equivalencies for oxycodone. And in his testimony, he says that although heroin is more potent, it is punished less severely with a marijuana equivalency of 3,000 grams. In your view, is he correct that we do have a proportionality problem, putting what we do with hydrocodone aside right now? Do you think with the opioids, there is a problem in proportionality between the different drugs?
No, and when you're comparing oxycodone to hydrocodone, no. I think that heroin is becoming a problem, but you have to understand that our use of heroin is a symptom of our opioid abuse. In 2011, we had over 16,900 people die of an opioid overdose. That's not heroin. That's drugs like oxycodone, hydrocodone, morphine, methadone, fentanyl, and oxymorphone. Only 4,400 people died of heroin that same year. So
Is that because of accessibility rather than potency?
I think that it's a little of both. I think potency has a lot to do with it, but so does accessibility. Remember, hydrocodone is the #1 prescribed drug in the United States of all drugs. Antibiotics. It's over 130 million prescriptions were written for hydrocodone. So it's a highly accessible drug. Now that number is going to go down because of the rescheduling action. But everybody believed that hydrocodone was not as potent because it was in Schedule 3. That's where the legal fiction comes in. It should have never been in Schedule 3. It should be treated as a very potent opioid because it is a very potent opioid. So I believe that the sentencing, if you make it in parity with oxycodone, you're not doing an injustice. You're actually...
No, I understand that. I'm just wondering whether oxycodone, as compared to heroin, whether we've got it right.
Oh, absolutely. You absolutely have it right. I think that, again, oxycodone is, in my view, more dangerous than heroin because it's a legitimate drug. People don't realize that you could overdose just as easy on oxycodone as you can with heroin. And it could be used similarly to heroin. It could be injected just like heroin. Those 15 and 30 milligram tablets are being injected. They're being snorted. They're being smoked, just like heroin. So in the end, I think that, yeah, you got it right. It's just bringing the hydrocodone up to the oxycodone since they're very, very similar drugs.
Coleman.
Yeah, I'm sorry, I'm making faces while I hear some of this. Joseph is hitting on some points from his
We'll have to
background.
switch the camera right over there.
Whoops. And some of the data. I have to strongly disagree. You note the points we made in our written testimony, but keep in mind, Congress set the 1,000 to 1 with what? Heroin to marijuana. Why did we have initial focuses on heroin besides it's very illegal? All this started with the opium poppy. It's got 3 alkaloids: morphine, thebaine, and codeine. What historically has been the biggest addiction problem in the United States going back to the 1800s? Morphine. We had the soldier's disease after the Civil War. Morphine. And all these other opioids that we currently use in Europe were developed as alternatives to get the analgesic effect without all the consequences and addiction problems of morphine. If we look at the definition of opiate in the 1986 Act, it defines it as something that has morphine or morphine-like qualities. So when you look at the drug equivalency table in the application note, you've got a 500 to 1,000 ratio between morphine and heroin, which makes sense because it's pretty accepted that heroin is twice as potent as morphine. Remember that heroin came along, and before they understood what it did metabolically, it was to stop morphine addiction. And then they found, and I had a medical chemist tell me, and this was really interesting, was all heroin is putting a vinegar molecule on top of a morphine molecule. It gets in the body, it's stripped down for faster application with metabolism, and boom, it goes in. So when the Germans in Bayer came up with, I believe, yes ma'am, the hydrocodone was developed as an attempt to synthesize codeine. It's chemically different because it's from different alkaloid. They're in the same family, it's organic chemistry, they've got the same base, 5-point structure, but then they differ with what's put on the ends. And you can ask your experts about the chemistry. But this rogue clinics, pain clinics, this is coming back. Again, in my district, I know in eastern Tennessee, I worked there 14 years. I was on the panel from 98 through 2006. I never had a hydrocodone case. I never heard of too many, beyond maybe less than 10 Lortab cases. That was in the Eastern District. That was in the Chattanooga Division.
Have you surveyed federal defenders' offices across the country to see if your experience is indicative?
The Defender Services did survey different offices, and it's really kind of coming down to what's unique with the 5 top districts that are identified, with the exception of Florida, where they do have some pain mills, pill mills down there. But I know in the Eastern District, and there are some in the Eastern District, Kentucky, the dynamic my co-panelist is describing is, it's not that it's non-existent.
Are the defendants seeing an increase in hydrocodone cases?
No, ma'am.
All right,
I did.
So you would say your district is representative?
Yes, ma'am.
All right, I just want to.
No, and when Zahydra was approved, when I heard it had no tamper-resistant qualities at all, the first thing was like, my God, this is going to be a contact crush. There are going to be people dying everywhere. And I tried to protect our panels with that when we had our CJA conferences, and did a very lengthy presentation, the whole thing. I got the weights from the manufacturer because I knew POs and everybody were going to be worrying about the weight. We haven't seen Zahydra approved by the Board of Pharmacy to be distributed in West Virginia yet. So we seem to be premature and jumping the gun by jacking up the multiplier. Moving to Schedule 2 has a practical benefit on legal dispensation. Let's give it a year and see how it works. If the cases spike, we'll know what to do.
Thank you. Judge Breyer?
Well, I was interested in your testimony that you've done extensive scientific inquiry, and I wanted to flesh that out a bit because this are you referring to the inquiry that was done in the rescheduling of the drug?
Yes, sir.
And that was. Can you give me a little bit more of a context of that? Flesh it out a bit.
Sure. When we do a rescheduling action, our scientists, we have Ph.D. pharmacologists, just like FDA. Our scientists look at all the literature, review the drugs, review the pharmacology of the drug, review the medicinal chemistry of the judge, look at different things regarding receptor affinity, things like that. And their research is done, then it's sent over to FDA, and FDA's research is done. And then it comes back, and then they sit down and they talk.
And how long is this process?
Well, for this drug, the process started in 1999, and we finished in 2014.
So it was about a 15-year inquiry?
Approximately, yeah.
And are you familiar with any similar inquiry with respect to marijuana?
There've been a lot of studies going back.
Schedule 1.
Schedule
drug, right?
1, correct, sir.
And the FDA claims that there is absolutely no medical use of that.
Yes, sir.
And is a similar inquiry going on with respect to marijuana?
There have been several inquiries going on with respect to marijuana, sir. In fact, we've had, I think, at least 2 reviews where both our scientists and FDA scientists have done those reviews, and they've come back with there's no medical
Is there
therapeutic use for
presently
the
any
drug.
inquiry going on with
I
respect to
believe there
marijuana?
is. Yes, sir. I believe there is.
And do you have any idea when that's going to come back?
Again, that would be a better question to be posed to the FDA.
Okay, thank you.
I myself in Boston haven't seen hydrocodone cases. Maybe they're there. I haven't received any, whereas really everyone's focused on oxycodone. And you just, so it does strike me geographically, there must be huge differences on what's happening. So I am interested if you could get the data on how many actual prosecutions there have been geographically where that is, because it isn't something that at least many of us have had experience with. You say in your testimony, or the department does, and I'd be curious about both what you all say, is that an addict may start with hydrocodone combination tablets, which cost $5 to $10 a tablet, then progress to the oxycodone, which is $30 to $80 a tablet, and then when she can no longer afford that, she may buy 10 bags of heroin. Is that something that is a hypothetical addict, or something that you've seen statistically is the course that an addict will go through?
No, that's what we're seeing. That's a reality. What's happening is hydrocodone, because of its schedule, because it was scheduled in Schedule 3, it was widely available. So say you're a kid and you start, either you've been injured and you start taking hydrocodone because a doctor prescribes it, or you're at a party and somebody got into their parents' medicine cabinet and got some hydrocodone, they pass it around. Some kids have a very, very great euphoric effect when they take this drug. So they're chasing that effect, so they want more pills.
So why would they go to the oxy if you're saying that they're equivalent, what was it, euphoric values? I can't remember what
Because your body builds a
Seems from this as if they
tolerance.
prefer the oxy because it's got a higher potency.
Because you build a tolerance to the drug. And remember, we're only dealing with, back then, hydrocodone combination products, the 5, 7.5, and 10, and it's got aspirin or acetaminophen or ibuprofen in it. When you're dealing with a small quantity and you're building a tolerance to the drug, and tolerance is not addiction, tolerance is tolerance, but you need more drug to get that same effect. And pretty soon, you're looking for a stronger, more potent drug. Now, oxycodone is not 10 milligrams. You could find the immediate release oxycodone in a 15 to 30 milligram tablet. And it doesn't have any acetaminophen, and it doesn't have any aspirin, so they go to that. But those tablets are not $5 a tablet. Those tablets are between $20 and maybe $50 a tablet. And now as you build a tolerance to that drug, to that particular oxycodone, you need more drug on board. You can't afford it anymore because it's just too expensive. You can't afford a $300, $400 a day habit because you're taking multiple pills. So then you go to heroin at $10 a bag. Heroin is the cheapest opioid on the market right now at $10 a bag. And that's why everybody's going to it.
Commissioner Friedrich?
So you don't agree with Mr. Coleman's testimony that the quality of the high with oxycodone is greater than hydrocodone?
No.
Are you seeing, you say you don't see very much hydrocodone, Mr. Coleman, but do you see that progression?
Well, the migration has been based on something, and they all give a euphoric effect. But then as soon as the 80 milligram Oxycontin's dried up, and they got the tamper-resistant qualities in 2010, people started turning to Opanis. They started turning to Dilaudid. They didn't immediately go to heroin. There was a big crackdown on that because, well, that's what we were seeing. We weren't seeing hydrocodone or Vicodin or Lortab. Now we see people going to heroin because they are so strung out. They have abused buprenorphine, Suboxone, and methadone. At some point, it becomes fungible. Just how do we get rid of being dope sick and getting high? There is a degree of tolerance, sure. There's also a great degree of interchangeability, but when you get down to actual preference, and we cite that in a written testimony, out of the 9 out of the 8 studies we hit on, identified a much stronger preference and euphoric, perceived at least, euphoric effect with oxycodone. There's one, and I believe the author of that is going to be testifying on another panel, who says they're the same, but that's not what's being reflected in the field. The tolerance does have some impact, but once they start getting truly addicted at that point, they want the strongest thing they can get. and it's only when there's nothing to buy they go to heroin. And hydrocodone is not weaving its way into that mix as an HCP or a single entity product, at least not where we're working.
Okay. Did you go first?
I was just curious, what's the state of the abuse deterrence that, I guess DEA works with the FDA to talk about the potential for abuse of the pills, how easily they're crushed and whatnot. So what's out there now that's easily abused, and which ones seem to be ones that have been regulated sufficiently by the FDA that it's less of a worry? Because I know that was part of this, is sort of how easy is it to crush or use in these kinds of forms. Is the FDA done its job in making sure that these drugs aren't, I know it's a little that's outside of our jurisdiction, but it seems related to the law enforcement needs.
FDA is actually pushing the manufacturers towards abuse deterrence. But remember, abuse deterrent formulations don't have anything to do with oral abuse, which is the #1 type of abuse. The only thing those abuse deterrent formulations will do is stop them from crushing and snorting, crushing and injecting, or crushing and smoking. For instance, the OxyContin, the OP tablet, that tablet is very difficult to circumvent. That delivery system is almost impossible to circumvent, and it's done a great job. That doesn't mean OxyContin is not being abused. It's being abused orally. They double the dose and take a potentiator with it. But in the end, we will see a lot less deaths if we have a lot more abuse deterrent formulations for all of the opioids. That is the FDA's right on track. That's the gold standard. If we could get all of these drugs, but those Oxy 50, just so you know the extent of this, OxyContin was not the drug of choice in Florida back in 2008, 2009, 2010, coming out of those pain clinics. They were Oxy 15s and Oxy 30s. Those are immediate release with no abuse deterrence. That was OxyContin pre-2010 had no abuse deterrent formulation. The delivery system was easily circumvented. But in 2010, 43% of all of the oxycodone products, the 15s and 30s, were going down into Florida. 43% of the whole country, oxycodone 15 and 30s were going down into Florida. Okay? OxyContin was not the problem in Florida. It wasn't even close to the problem in Florida. The problem was those immediate release products. And they had no abuse deterrent formulation. And as far as going to oxymorphone is another regional drug. If you're in Appalachia, oxymorphone is the drug. But if you're outside of Appalachia, no one's going to oxymorphone.
Yeah, Mr. Coleman, can I ask you one question on the, we're about to hear from the experts.
Yes, ma'am.
But we've read the testimony. I mean, the scientific evidence, a lot of it seems to suggest they're equivalent, and you say they're not. Do you have an expert or a particular report you want to focus us? You say there are 6 reports there. Is there a particular expert?
I know Mr. Cicero I don't know why he's not a witness before the panel. I know he was.
So is there a report in here that we should be reading?
I don't have one from him. We can certainly submit it with the comments for consideration by the commission, and would like you to certainly consider that.
It's not cited in here.
There is the Rachel Reitman article from September of 2012 is in our written testimony. That's the Journal of Medical Toxicology, where they surveyed the leading articles through a pretty rigorous survey methodology to analyze just the relative abuse liability of hydrocodone, oxycodone, and morphine. And the consensus from that study and the review of the 9 studies they pulled out of 16, again, with a pretty rigorous criteria, are the ones that suggest the abuse liability, at least for oxycodone, is substantially greater.
So you'd have us focus on that rather than the scientific equivalence in terms of the analgesic and properties?
The problem with that is that we have one textbook that says they're even. Every pharmacist I've tried to consult and talk about it when I was trying to get up to speed on this, not for this commission, but in my practice, was, it's always relative. It's relative to individual metabolism, body size, prior opioid use, that while we have one textbook that says there's a direct equivalency, it's not the only source out there. We cite some sources in our testimony where we feel they're different. And that alone, I think, we had proposed we need to study this more for that reason. We need more sources of information before we just jump up to 6,700 or 4,475. And that's why we have proposed leaving the HCPs where they are. And if we're going to go to a higher ratio with actual ingredient weight, which really we should do,
So you, but you say if we read this Reitman article, that's going to say that it doesn't have the same abuse
yes, ma'am.
liability?
Absolutely.
Can I ask
All right, thank you.
So you cite, if I could, you cite an article that talks about something called the opioid analgesic converter. I don't know if you recall that, but that's one of those where you said there was a difference, and yet when we looked at it, the table there seemed to say that that the doses were in fact equal or at least overlapping.
I will need to go back and look
Okay,
at
if
that.
you could cite to us anything that
Sure.
suggests the difference, because the two tables that you cite seem to suggest something consistent with what the FDA witness is going to be testifying, that the dosages are the same for oxycodone and hydrocodone.
I would simply point out, I will supplement that, but let's say at the end of the day, the consensus is the equianalgesic effect is the same. That doesn't validate the 6,700 multiplier or that big a difference between heroin, where we have the statutory relationship established, and the 6,700 multiplier we've done since 2003. How deterrent, what's the deterrent effect of that been if we look at the numbers? Because using the time Joseph was talking about, between 2006 and 2012, there were 3,200, 51 oxy cases, and 469 hydrocodone cases. That big a difference, even though...
Could you say those numbers again?
Yes, ma'am. 3,251 versus 469
And that time period was?
between 2006 and 2012.
And heroin abuse is rising. Are you all going to be back here in a year or two saying we need to raise heroin up to match oxycodone and hydrocodone?
I can't speak for the department, but what I can tell you is heroin abuse is rising because of hydrocodone and oxycodone. That's the reason. And if we control hydrocodone and oxycodone, if we could limit the amount that's going into the abuse, limit the amount that's going into the drug-seeking community, we're going to save lives, and we won't have a problem with heroin. Our issue right now is controlling the pharmaceuticals. And if I can make one more comment.
And then we do need
Okay.
to wrap up. Then.
Well, before you do, I just want to follow up. Are you saying that if we raise this level as suggested, the level of punishment, we are then going to reduce the heroin abuse, and there's scientific evidence of that?
No, what I'm
Or is
saying.
that a hope? Is that an aspiration? Is there scientific evidence that supports that
There's
statement?
scientific, well, there's evidence that shows that people are starting on drugs like oxycodone and hydrocodone and moving to heroin. If we had an addiction specialist at this table, that addiction specialist would say the vast majority of their clients started with hydrocodone and oxycodone.
Well, but you start somewhere doesn't necessarily mean that then causes the higher the use of another drug later on. I mean that's I've heard that for now 50 years. And it's been in the field of marijuana. You start with marijuana, people are going to be heroin addicts. I mean I've listened to that. So the question really is there some controlled, satisfactory scientific evidence that shows that if we raise the penalty for hydrocodone, we will then reduce the incidence of heroin abuse? Is that what you're saying? There's scientific evidence for that?
I don't have any study that shows that, but hydrocodone and oxycodone and heroin is not marijuana. People don't die from marijuana. People don't overdose from marijuana, but they
No,
do.
we know that marijuana is a Schedule I drug.
Yes, but we also know that there's a natural progression based on tolerance from one opioid to another until it reaches heroin. I mean, this is not marijuana. This is not the gateway theory. This is science. You build a tolerance to the drug. Once you build a tolerance to the drug, you need more drug. You have a panel coming up with two very, very distinguished scientists, Dr. Hertz and Dr. Walsh. They could much better explain tolerance to me, but eventually they're going to need more drug on board if they're chronic users.
All right, we're really over, but Commissioner Friedrich has one burning question, and then we're moving on to the
Just back
next
to my
panel.
original question. Which is more potent, heroin or oxycodone?
Relative potency, I think you need to talk to the two doctors that are coming up in the next panel.
And we will. So,
If I could wrap up, Judge Breyer, to answer your
10
question.
seconds, because we're really now way over. All right.
Page 23 of the government's testimony, footnote 20. You will find the exact opposite, that this is not, hydrocodone or is not a gateway drug to heroin. The study cited by the government's own testimony has a different conclusion. The vast majority do not within 5 years of having used it.
Thank you very much. We'll move on to the next panel. Sharon Hertz is the Acting Director for the Division of Anesthesia, Analgesia, and Addiction Products, Center for Drug Evaluation and Research at the U.S. Food and Drug Administration, and has held that position since September 2014. She's been on the staff at the Food and Drug Administration since 1999, serving in various capacities in the Division of Anesthesia, Analgesia, and Addiction Products. Dr. Sharon Walsh joined the University of Kentucky Colleges of Medicine and Pharmacy in 2005, is a professor of behavioral science, psychiatry, as director of the Center on Drug and Alcohol Research. Dr. Walsh's clinical research has focused on pharmacological and behavioral issues in opioid abuse and dependence. So, Dr. Hertz, welcome.
Thank you, Chair Saris, Vice Chair Breyer, and distinguished commissioners. So I will not read my statement, and I'll go over to say that we've been considering many aspects of this issue over time, as we've also worked to address issues of misuse, abuse, and addiction. And pursuant to the specific questions and information that you seek here, I will say that hydrocodone and oxycodone analgesic products have a number of similarities. So they are both opioid analgesics. They are both available in immediate release formulations in combination with other drugs, most frequently acetaminophen, and both as single entity extended release formulations, although as stated, only oxycodone is available currently as a single entity immediate release product. Both drugs are now in Schedule II of the Controlled Substances Act, and they both share long marketing history and substantial market share. The potency refers to the dose of a drug required to produce a given effect, and there is not a lot of information available about the actual potency for different opioids, the relative potency. But the data that we do have from a variety of sources suggests that hydrocodone and oxycodone are similar in potency when used as an analgesic for pain management. The relative potency can differ based on different pharmacodynamic effects. However, there are many factors that result in inter-individual variability. I will also just state that our controlled substances staff has reviewed a number of studies, 6 studies published in the time between 2003 and 2010, and they concluded that based on those studies, hydrocodone single entity and combination products produce similar euphoric effects to morphine and oxycodone in a dose-dependent manner. And I'm happy to answer any questions that you have.
Thank you. Dr. Walsh?
So am I on? It's a great pleasure to be here today, and I thank the chair and the panelists. I will try not to read from my statement, and I wanted to actually just give an abbreviated statement that would highlight 2 points that I felt were the things that I was specifically asked to address with respect to the report. However, after hearing the last panelist, there probably are some other things that I would like to add in maybe
Sure.
during the panel time. And so in starting out, I'd like to say that what I actually do, aside from those titles, is that I work with substance abusers every day. So we provide treatment to opiate-dependent individuals. We enroll them into studies, both as inpatients and outpatients. We get to know them. So we know a lot about what their what their patterns of use are, and certainly we know what it looks like on the ground in Kentucky. I had been in Baltimore in the inner city for 15 years before that, so I know a lot about what heroin looked like there as well. So with that, I'll go on to addressing the two topics that I specifically wrote about. And the first was with respect to having sentencing tied to actual drug weight versus the unit of drug. And I think in agreement with the prior speakers, it is very clear that using actual drug weight is the only really appropriate answer here. Hydrocodone is available in literally hundreds of different formulations in combinations with all kinds of other things, sometimes active ingredients that are not narcotics, like antitussives or acetaminophen. There's a lot of inactive ingredients, and with the new abuse deterrent formulations, some of those ingredients actually can weigh quite a bit. So in thinking about trying to harmonize things, looking at actual weight seems to be the most fair and appropriate approach. And this is what's been done with oxycodone, and so that seems to harmonize between those two. The second issue is a little bit more complicated, and this is with respect to trying to determine the severity of sentencing with respect to equivalencies. And so you've heard a lot about that already this morning, about whether or not oxycodone and hydrocodone are equipotent. And so there are two proposed amendments, one that proposes an equivalency of 4,500 grams, and the other that's more severe that proposes 6,700 grams, and that's because the reports that were used in order to establish those estimates for this consideration were two different written published sources that have disagreeing potency comparisons. In both cases, those are actually analgesic equivalency tables. And so I just want to say a word about using analgesic equivalency tables. This is actually not necessarily a scientific document. It's not necessarily something that's been derived from scientific studies. These are important guidelines that physicians need to have in their back pocket when they're treating patients with pain and they're trying to convert them from one drug to another so that they make sure that they don't overdose or underdose somebody. But the way that those data are derived are often unknown, and if you look at the source documents that are in the report, you'll see that many of them don't have any references that actually tie them back to the scientific literature. And that's because some of them are done from clinical experience, and others come from pharmacology textbooks. Some come from studies where people were dosed chronically and maintained on an opioid, and then they were rotated to something else, which is common in terminal care, for instance. But others are with single acute doses, and you can imagine that all of these things make for a mixed bag of findings. And so I think that that really defines the reason why you can look at, I have a stack here of different analgesic tables, and there's a big number of different outcomes when you compare the drugs. But the other thing to think about, I think, that's important is that when we think about drugs of abuse for which penalties have been devised, really, for instance, like with cocaine or hallucinogens, there isn't some clinical therapeutic application that you're going back to look at and determine the strength of the drug and how it's been used clinically to help make decisions about punishments. In this case, it just so happens that the opiates are used as analgesics, and so that seems to be the reason why there's some reliance on this. In my opinion, I think the more important thing here is because the drugs that we're talking about them being abused and not being used as analgesics, is that what's relevant is the relative abuse liability. And so we've done studies in our laboratory examining the relative abuse liability of these drugs directly. I will say that there are very defined criteria that are approved and codified by the Food and Drug Administration. The Food and Drug Administration requires these types of studies for new drug approvals, and these studies are used to inform the Drug Enforcement Agency about scheduling decisions. With respect to the former speaker who referenced a review article that concluded that oxycodone was more potent than hydrocodone by review of some number of papers, most of those studies were actually done in normal, healthy controls. And the FDA guidelines recommend that abuse liability studies be conducted in a target population, and that is the people that are actually abusing the drug. Because if I were to give the panel morphine or heroin, and I asked you how much you liked it this morning, you might not like it very much because you probably are not a heroin or morphine user. And lots of people, if you've had the experience in the hospital of having an opiate, say, after a surgical procedure, it's very, very unpleasant. So when you're thinking about abuse liability, it's really important to target the population who's self-selected. They know they're using these drugs. They like these drugs. And so if you're interested in the likability of these drugs or the street value of these drugs, that's the population that you want to study. And there actually are only a handful of studies. And so the one review article that was referenced, many of those studies don't actually qualify under what the FDA would recommend. So with that being said, I can tell you that we have directly examined within the same subjects a whole range of doses of oxycodone, hydrocodone, and hydromorphone given orally under very controlled laboratory settings. And we find that the drugs are very, very similar with respect to the profile of effects. They produce all positive effects. There's no negative effects in this population, unlike in normals. And then there's a more sophisticated statistical technique that can be used that is accepted in pharmacology for understanding how to actually calculate with validity the relative potency between or amongst drugs. And in this case, for that study, we were able to use those data and do this Finney bioassay. And we found significant findings where we had valid comparisons across a number of different measures, both subjects telling us how much they like the drug, observers who were in the room watching how intoxicated the person is but not knowing what dose they got that day, and then also some objective measures like physiological responses to the opiates. And what we found was that the relative potency estimate was 0.929. And what that means is that 0.929 milligrams of oxycodone is needed to achieve the effects of 1 milligram of hydrocodone. So it's not 1-to-1, but it's about as close to 1-to-1 as you can get with respect to not just these abuse liability outcomes, but also some other objective markers. So that's really the end of what I had wanted to share with those two specific topics. But if I have permission, I'd like to go on to say one other thing, and that is one of the things that didn't come up in the discussion with the earlier panel. If these drugs are equal in their potency and equal in their euphoric effects, and in fact hydrocodone has actually historically been more available, why do we hear more about oxycodone, and why is that more of a problem? One of the things that wasn't raised is the fact that hydrocodone has historically been available only in these combination products. And people who are escalating their drug use, they may remain an oral user, but more often than not, when someone is actually really getting into trouble, they're going to escalate to use a different route of administration that provides a better drug delivery. So they'll start crushing and snorting the drug because you get better bang for your buck that way. That's an official pharmacological term there. You get improved bioavailability, but from their perspective, it's a better high for less money for the same pill. Or you inject it, where you get 100% of the active ingredient, and none of it is going into your gut and being excreted out without getting the fun of it. The problem with hydrocodone products is that opiate abusers know that acetaminophen is dangerous. Everyone knows that and they know people who have landed in the hospital in liver failure because of this. And so they know that it hurts when they snort it, and that people can develop holes in their septums that don't heal and ulcerations. And so we don't see people escalating their use with hydrocodone products, I think largely from the reports of all the people that we see, because of the fact that it hasn't been available as a single entity product. It is now, we all know that, so hydro was in the news, it was a big controversial thing. It really, from my perspective, where we are, it hasn't penetrated the market, but we now are doing a study with it, and it costs more than $500 for one bottle, so that doesn't surprise me that it hasn't really penetrated the marketplace yet. And also, because of the concerns about it not having abuse deterrent protection, a lot of formularies actually are not putting it onto their formulary, so I think it's a little bit challenging to get. So with that, I'll stop and take any questions.
Thank you, that was very helpful. Any questions?
I have a couple of questions. Dr. Walsh, do you agree with statements that were made in the last panel that the increase in heroin use is related to pharmaceutical use and abuse? That's number one. And then in addition to the changes in the guidelines, are there any steps beyond criminal penalties that you think we should, as the Commission, recommend to Congress or the Office of National Drug Control Policy to address this serious problem?
With respect to the first question, whether I agree that the prescription opiate epidemic has led to an increase in heroin abuse, I think the evidence is strongly supporting that that's the case. So, and a lot of it is an unfortunate byproduct of effective strategies that the government has used to try to crack down on prescription drug abuse. So the FDA has been very committed to encouraging pharmaceutical companies to develop abuse deterrent formulations. The new OxyContin formulation essentially suppressed its use. I mean, we have data from Appalachia that are just remarkable in looking at the decline in abuse in a cohort of drug abusers that we're following. And at the time that that drug came on the market and the old one was pulled off the market, people immediately moved to 30 milligrams of a generic oxycodone product. But what's happened in addition, of course, is that there are prescription monitoring programs that are really enforcing things much more rigidly with physicians. Physicians are becoming much more aware of prescribing practices, and there are now some requirements for additional education for physicians. The DEA has been much more active in physicians who are investigating physicians who are prescribing high volumes. And so with all that, that's led to is an increase in the street price for prescription opioids and a declining availability. And so, and I know that for the last couple of years, the sales for oxycodone actually have gone down nationally, which and that's provided an opportunity for a new marketplace where we have Mexican heroin being transported into places where it never was. I can tell you that 10 years ago, moving from Baltimore, which has always been a heroin city, as they like to say, when I came to Kentucky, there was no heroin. And everyone that came through my door and I interviewed about what they were using, they were all using prescription opioids. They looked the same as heroin abusers. The degree of their disease and disorder was just as extensive, but they had not experienced heroin. And if they told me that they ever had, I knew it turned out that it was because they had been someplace else. They had gone to Chicago or they had been to Cincinnati. We just didn't have it in our area. Now, in 2015, I can tell you that virtually every person that walks through the door is using heroin. Not alone. They're using it to supplement their prescription opiates, but the heroin is much cheaper. And so we're seeing more advances to intravenous use as well. And then your second question, is there any
other steps?
Yeah, are there other steps that can be done? So I have to confess that because I'm a scientist and I'm very treatment-oriented, that I have not done much research on how the impact of laws work on suppressing use. What I know is that I see people using all the time, and so we haven't eradicated the problem. I think that there are a number of different strategies that are being implemented right now, and they're working. It's just that there's a balloon effect. And to your point earlier about people advancing, from marijuana to another drug, these actually are all in the same class of drugs. So that it's a little bit different. They once you are dependent, physically dependent, and you need that drug, any one will do. It'll substitute and suppress your withdrawal symptoms. So I think the one thing that I would say is that I really did hear the prior speakers' concerns about whether or not the penalties were balanced with heroin, and I realized in looking back that I don't know or understand historically how all that evolved, but I do know that we have science that could inform it, just as though we are talking about the science today, and that if that was something that was under consideration, that we could apply that, and there are data on heroin potency that we could look at to see whether or not the penalties were in balance.
So, Dr. Walsh, that was the question I was about to ask you. Your testimony is very compelling. suggesting that these penalties for oxycodone and hydrocodone should be equivalent. But what I'm wondering, based on all the testimony we've read, is whether we've got it right across the table. And you've certainly suggested that actual weight is the way to go, and our table right now doesn't do that across the board. So I was going to ask you if you had a sense as to whether these drugs are calibrated appropriately, proportionally to other drugs. And it sounds like you don't have an opinion right now.
So I don't have an informed opinion. We all have opinions, right? I don't have an informed opinion because I haven't had enough time to really look at it, but I was so amazed that all the penalties were tied back to marijuana when I first got the report to review, and I didn't really understand how that came to be. And then when I read Mr. Coleman's testimony, and I actually wrote to the people who were organizing my visit, and I said, you know, I didn't think I was asked to change the whole system. Like this, he's really recommending quite a few changes. I thought that I was being asked to comment very specifically on the pharmacology, but I think that there's some merit to the things that he's saying, and if that was something that the commission wanted to visit, that I would be willing to help with that, because I actually do think that we have data that can inform that, and I'm not going to sit here in judgment and say that the way that it's arranged is not correct, because I don't really feel like I understand enough, but
you do agree that we should move to actual weight rather than
yes,
mixtures and
yes,
combinations?
yeah, oh yes. I mean, there are. Well, actually, Dr. Hertz can speak to this probably more carefully than I can because she knows a lot about drugs that are in the pipeline. Maybe you can't because of confidentiality, but you know, there are many drugs that are being developed, say, as abuse deterrent agents, where the weight of the excipients or the other ingredients are a lot more than the weight of the active drug. And so if someone's being punished for the plastics that are in there, for instance, or whatever, that would be really most unfortunate, because then you could have someone who has pure tablets and has, you know, I mean, so it just makes it for an uneven playing ground. So I think that to me is a very logical.
Can I ask you, Dr. Hertz, to follow up on that? So as I'm understanding, it's very helpful that Dr. Walsh is saying that the reason people weren't using the hydro rather than the oxys because it was in combination with acetaminophen, is that right? And now that we've got these single release tablets, that may change. So what does the FDA think about when they approve these drugs that can actually create the abuse liability?
So,
Maybe I'm backing into something, but hydrocodone, it sounds like, wasn't such a big problem because it was in combination with these other things. And now we have Zohydro. And you know, there's a big case up in Massachusetts on this, so.
I'm aware. As a representative of my agency, I can say that our appearance here today is limited to providing the commission with scientific information related to the relative potency of hydrocodone and oxycodone, and I'm not able to offer information related to other policy issues. I know that's not a satisfactory answer, but...
Well, perhaps I could ask this question. If I understand the testimony today, it is that drugs are being developed and being approved and being encouraged, in a sense, that will have some abuse characteristics to it in order to curb
Abuse deterrence.
I'm sorry, abuse deterrence, that will discourage the inappropriate use of the drug.
Yes, that's
correct.
true.
And that has some real weight. That is to say that if you analyze the drug, that will be a significant component in the weight.
Yes.
And so it would seem to me, if both of those things are true, it would be odd. It would be odd to punish in a more severe way a drug that has the abuse deterrent than one that would not. It would be absolutely counterintuitive that one would give a more severe sentence to drugs that have an abuse deterrent than one that does not.
Yes, I can say...
If the idea is to discourage the use of unsafe drugs or without a prescription.
Yes, several of the approaches to develop abuse deterrent products can add a substantial amount of weight can double or triple the weight even of the actual tablet without changing the
Double or
amount.
triple?
Without changing the amount of opioid in the tablet.
Patty, can I ask it? So on the actual weight issue, so I'm thinking about our drug policy overall, and it's actually unusual for us to look at the actual weight in other contexts. So, we don't see how pure is the cocaine or for other drugs. And the argument there has been, that I've seen, has been, well, that's because that's not the market, isn't really about that. You kind of buy or sell in doses, and it's not so much about purity. And I'm just curious if either of you have a sense, in your experience, if this market is different in terms of people paying attention to the dose amounts on the tablet, or is it something that if we think actual weight is the thing that matters here, it's something we should think about broadly for all of our drugs, because it turns out all the things you were saying would transfer to the other drugs that we look at. And the counter-argument I've seen there has just been, yeah, but the market isn't reflecting that in the same way. So I'm just curious if you could comment on what this market might look like in terms of the drugs.
Yeah, so, it made all of this, for me, participating today has been fun to be able to read all the background and to think about some of the questions that I haven't thought about before. And that's one in particular because there are big differences between drugs that are only sold illicitly, where someone goes to the street corner or their favorite dealer, and they don't actually know what they're getting, right? And the test of whether or not it's good or not is whether they decide to come back and buy more. And so when you arrest someone and they're in possession of cocaine, for instance, or heroin, you have no idea what the purity of that is. So we could do a test in the laboratory and find out what the absolute relative potency of heroin is to oxycodone, for instance. But what is sold on the street could be 80% pure heroin, or it could be 20% pure heroin, and the rest of it could be quinine or something like that. And you just have no way of knowing that. And I'd asked the DEA, Mr. Rannazzisi, earlier about whether or not for all arrests, do you test purity so that you can assess what the punishment should be? Do you know actually what number of milligrams somebody was holding? And so we were having that discussion. I think with the pharmaceuticals, it does make a difference because we know exactly what's in it, and so do the consumers. They know, so if you buy a Xanax, you know what's in it. If you buy an Oxy 30, you know what's in it. But back to, another aspect of the weight issue, if you have a 5 milligram tablet, which is not currently a bit, well, maybe with the high single, I'm not sure, of hydrocodone, but then you have another hydrocodone that also has 325 milligrams of Tylenol in it, the weight there is very different, but the actual amount of active drug is the same.
So it's interesting. I've learned a lot just listening to the two of you. So essentially, these scientifically, they're equivalent in terms of potency, but on the street, people want oxycodone because they can get it in the purer form more easily, at least until this other product came out.
Right, because it's more flexible, because you can use it by snorting, you can inject it. You shouldn't. It's not a good idea because it's got things in there that aren't good for you, but it doesn't have acetaminophen in it necessarily. And so I think that plays a big role. I think one of the things that we're talking about, one of the things that the FDA has to be thinking about, whether they're allowed to say it publicly or not, I know, is that what the concern is that, once Hydro got onto the marketplace, and that was very controversial, although you had no choice because they'd proven efficacy, right? And
So
she can't. Well,
She can't say things
no.
that-
I mean, I think that the rules are that if they can demonstrate safety in the population and efficacy, then it has to be approved. And I think that was the basis for the FDA approval. Although they took a lot of flack for that. I think that the concern is that now that there's this precedent that there will be more single entity hydrocodone products, and it's going to become exactly like oxycodone, so that it's a big bubble, and there's a bunch of opioids that you can choose from, and if you squeeze here and you prevent this one from being available by cracking down, it expands someplace else, and that's where we see the heroin expansion coming.
Can I follow up on Commissioner Wroblewski's question then in terms of things we would recommend to Congress or policy things? Is it the case that the FDA in making this approval process doesn't take into account abuse potential, sort of the off-label abuse kinds of things? Would it be the case your hands are tied, you have to say yes without considering that doing it? Is that a legislative
I can
fix?
answer that. So
Okay.
we can take abuse liability into consideration when we approve a product with an abuse liability. And we do look at it in the context of the armamentarium and the relative risks. So we do, and that is within our authority.
And they did with the Zohydro, and that's how we know each other. And then, if I'm correct, then that information gets sent on to the Drug Enforcement Agency for them to make decisions about where to place something in the schedule.
But I mean, you have to find that the benefits in terms of like how much pain relief do people need? Some of these numbers seem, to a layperson. I'm just trying to think in terms of the kind of pain relief that people would need for pain management, or the kind of controlled setting in which they'd have it, whether they're hospitalized or whatnot. Is it that kind of cost benefit that you do to try to figure out where the drug would be administered, the risk to an abuse population? I mean, is it a pretty broad scale inquiry like that?
I'm looking over my shoulder to see if anyone's holding up a break sign or not, but what I can
No,
tell you
you've
is...
got 5 minutes if you want to.
That wasn't the sort of break I was looking for, but when we approve an opioid product, we look at how it compares to what's already exists. And I can tell you with regard to any recent approvals that we have not approved anything stronger than comparable other products on the market. And in fact, if we look at some of the information that we've discussed here about relative potency and look at what's available with other prior existing opioids, one can see that Zohydro is in fact no stronger than what's already existed using these rough relative potency estimates. When we think about the needs of individual patients, we know that there is a very wide range in needs, and we know that there is a lot of individual variability on many factors that will influence the amount of an opioid analgesic that they will need, both in the short term and the long term. So what we try to do is ensure that within the spectrum, when we approve a product, that it's meeting a need, that it has adequate evidence of efficacy and safety in the intended population for the indication. And we also look at it from a public health perspective as well.
Dr. Hertz, if I might, later on in our hearing today, we're going to address the issue of drugs which are flavored in a way that might be attractive to children, to youth. And I know you're here only on the Hydrocodone, but obviously we have the example of what's happening in Colorado with respect to marijuana. And I'm interested because the previous witness has told us that the FDA is conducting a study or studies in determining whether there was any medical justification for the use of marijuana. My question to you is, do you have any prediction not as to outcome, but as to when the results of that study would be known to the public?
Yeah, I'm not entirely sure of exactly what that study is that was referred to. I know that there are analyses underway of existing data, and I know that there is interest in the medical community, but I don't have specifics that I could share a timetable for because I'm not directly involved in that.
Okay, thank you.
I'm actually glad Judge Breyer asked. I was going to ask you, Dr. Walsh, you see so many boots on the ground in Maryland and Kentucky. Have you seen any issues of marketing these drugs to children through special packaging or advertising or colors or flavors?
Not with the opioids specifically. We haven't. I mean, what our concerns about with children largely surround the medications that are already in the home, that are in prescription bottles sitting around available, and the idea that because it comes from a doctor, it's legitimate and safe, and that leads to these pill parties where high schoolers are, who really have almost no drug experience whatsoever, suddenly find themselves taking some really potent opiate and, tragically having some terrible outcome. But we haven't seen that and I haven't heard about that as the heroin marketplace has infiltrated in the Lexington area, the Bluegrass area. Thank you.